Okay, I'm going to be calling the Administration Committee to order. Clerk Aliazi, could you please do roll call?
Alderman Kruger.
Here.
Alderman Zielinski.
Here.
Alderman Grady.
Here.
Alderman Benner. Alderman Nichols. Here. Alderman Taylor. Alderman Sevenik.
Here.
Alderman Collier.
Here.
Okay, the first item on the agenda is the approval of the Administration Committee minutes from 5/15/17. Is there a motion? Alderman
I'll move
Sevenik.
for the approval of the minutes.
Alderman Benner seconded. Is there any discussion? No discussion. All in favor of the minutes, say aye.
Aye.
The minutes are approved. Moving on to discussion action items, we have two items on the agenda. The first one is to review and discuss possible action involving the City Code Chapter 4, Section 2-4-6, the Park and Recreation Board, and Chapter 12-1-6. The following words of the fees were not supposed to be on the agenda, so please ignore those. We will not be discussing particular fees today. The reason why this has been placed onto the agenda, again, is because of the lease that was signed by the Park and Rec Board with the kayak place in reference to the Marina building. Myself and other aldermen have had concerns about this, and as I stated a month ago, I was going to have this on the agenda for discussion. We're not going to be discussing the actual contents of the lease because that's irrelevant. Just the process of who has the authority to sign the leases on behalf of the city for any city property. If the attorney or Brian could please explain again the process and what happened with the lease for the committee.
I can accept your faulty perception of the law. Perhaps it would be better if you could just describe to me what it is that you want and don't want the Park and Rec Board to do, and then we can make changes to the ordinance in line with what it is that you want them or don't want them to do. Because
Okay.
that really is what the issue is. What is it that you want them to do or not do? Does it matter if it's the marina, if it's all parks? Are we talking about buildings? Is it both buildings and land? Is it something that would be perhaps less than a year, greater than a year? Those types of things, and then we would put that into one of the sections. And of course, when it comes to the Park and Rec Board, it's the Common Council that decides what powers the Park and Rec Board have and what powers they don't have. It's totally up to the Common Council. If you want to, you don't even need one. You don't even need a Park and Rec, a Board of Commissioners. You can act as the Park Board if you would like to do that. It's just up to the Common Council. So whatever it is that you would like, if you could tell me that, then we can make changes to the ordinance in order to do that.
I agree, Attorney. As the emails that we've had back and forth, I was trying to explain to you that what my concern at least was I do not think it's a faulty perception that the Park Board is allowed to sign leases on property. And in fact, the Wisconsin Supreme Court also did have a ruling on this exact very subject on Krynick versus West Allis, where the a resident actually sued the city because they were underneath the perception that the park board of that city signed a lease for a trucking company to lease park property for business use. And the Supreme Court, in their decision, specifically stated that the Park Commission and Board is irrelevant in their actions with the lease because the Common Council is the proper authority to engage and activate any type of leases or anything else with the with property. And it's something that has bothered myself and other aldermen, and that was the purpose of this, is to discuss, to find out where the wording was in the ordinance that shows that they have the power to do this, so we can make a recommendation to the Common Council if they so choose, to change the ordinance so this does not happen again. So I guess the main premise is what wording gives them the authority, because it obviously isn't in statute, because the Wisconsin Supreme Court already stated that that's not in statute. So I'm trying to find out where in our ordinances does it give it that authority for basically anything long-term.
As I indicated, I know that some research was done that will, in my opinion, would be faulty legal research. So if you would just tell me what you'd like to do, that is something I can help you with. I can help debate. Well, I wouldn't be debating, I'd be writing. That's part of the city attorney's role in the statutes or in the ordinances about writing what it is that you want. Because the Park and Rec Board can only do what it is that the Common Council decides that it can do. So what is it that it appears as if what I'm hearing is that you're not happy that the Park Board decided that a company could use a room at the Marina building for purposes of providing recreational activities to the public without coming to the Common Council. And that's fine. If you want something like that to come to the Common Council, then we would be writing that. And then my only questions is, does it matter if it's, I mean, do you want that just to be at the marina, or do you want it to apply to all parks, all buildings, both land and buildings? You know, is a one-day rental of a building?
We're not talking about one-day
Or
rentals.
what is it that you would like to come?
It's the long-term leases, where the long-term leases of any park property or any building, along with contracts, comes before the council for approval. I don't think anybody up here has objected to the particular company utilizing that building. In fact, if it would have came before the council, I'm sure it would have been approved for the use of that. If other aldermen want to chime in here, I am looking for wording where long-term leases of any city property comes before the council for approval.
And what do you mean by long-term? First of all, I guess we'll start with that.
Well, long-term, the daily stuff, it would not be long-term. When you're leasing a piece of property to a company to do business for an extended period of time, that would be a long-term lease. Anything more than pavilion fees, or fees to have a festival for a weekend or something like that. This is a long-term. It was a one-year lease.
Well, can I talk once?
Just like that, button push though.
And so would that be, is it just applicable to the marina or to all park buildings?
All park for long-term.
So the use of all park buildings, and I mean, in order to write it, I just need to know if you want a time, if you don't want a time limitation, that's fine, but if you want a time, is it a month, is it a season, is it less than that or more than
This
that?
isn't strictly my call here, because there were other aldermen that wanted to discuss this, and Alderman Collier.
And I would just warn you about discussions of items that are on the agenda with multiple aldermen that are, outside
You
of a meeting.
You are misunderstanding what was said at previous meetings. Other aldermen had issues with this also, and at the meeting, I stated that this will become before the committee. There's no outside discussions happening.
Okay, good.
Alderman Collier.
When you say a length of time, what I would consider a lease of a length of time is a year. And the reason, and I'm going to ask a question, let's say someday we get lucky enough to get some vendor trucks to come down and want to stay at Jefferson Park for the summer months every night on a Wednesday. What would we consider that? I'm just asking the question versus.
That is actually already taken care of, Alderman Collier, because that's already done through the permits and everything else through the park departments, that the council, everything comes before the council, even the permit fees for food trucks and all that, and the council agrees to those prices, and then the Parks Department can administer that underneath those guidelines, and so a truck, I'm
Okay.
just gonna use.
So that,
when.
my question on that one, I'm not worried about now. Now,
Right.
when you talk length of a lease, is it a seasonal lease for a year? Or what we're gonna talk about, or what you'd like to see, or if we do, because we just did I think a 5-year deal for the ARC? The re, yeah.
That can be for council.
Okay, but I'm just,
And that wasn't part.
okay, sorry. We're talking about the art building, and that's not park property, so that made no difference. But I was wondering if you meant like a seasonal, year, 3 years, what would be the definition?
A lease would be the definition. A lease is a lease, a rental is a rental, a lease is a lease, no matter if it's a 3-month lease, a 1-month lease, or a year lease. It's a lease. Alderman Sevenik.
Oh, thank you. This isn't an issue about fees or someone coming in to rent a pavilion or something like this. This was a lease agreement with a business. And a lease agreement with a business does not take place in a board of parks or park and recreation board. They can enter and work out an agreement, but that agreement needs to come to the common council. Let me read here powers and duties of the Park and Recreational Board, and it says in here, parent E3, to recommend to the council. And part of that recommendation is the leasing of buildings, boat slips, even within the Menasha Marina. It's as clear as day. I don't know about the Supreme Court ruling thing, other than what's being said, but it's very clear that they're not an elected body. They are appointed for one purpose, to bring recommendations and ideas to the Common Council. And then we vote on those, especially when it's a legal written document in a rental agreement. That should have came back to this Common Council. Now, I know this happened before the new council came on board, I think. I might be wrong. But regardless, when we deal with finance, money, entering into agreements with businesses, we just don't have staff go ahead and do that. That has to be approved by this body. That's put in state statute. I think you might want to look at some of those. I have some here, but I don't know if they're updated because the last ones I read before were from 2014, so they may have been changed. I'm trying to find the dates on this. So, and I'm just looking at our own duties here and their responsibilities and our duties. You know, let me read Common Council ones. Seeing we're having this debate here, or this argument, we have general powers. Those general powers are very important. The Common Council shall be vested with all the powers of the city, not specifically given some other officer, except as otherwise provided by law. The Common Council shall have the management and control of city properties, finances, highways, streets, navigable waters, and the public service, and shall have the power to act for the government and the good order of the city for its commercial benefit and for the health, safety, welfare, and convenience of the public, and may carry its powers into effect by license, regulations, suspensions, borrowing, taxation, special assessments, appropriations, fines, imprisonment, and other necessary or convenient means. The powers hereby confer shall be in addition to all other grants and shall be limited only by expressed language. And then it goes on, I mean, I could go on and on. I mean, here it deals with properties. The Common Council may acquire property, real or personal, within, without the city, for parks, libraries, historic places, recreational, beautification, streets, waterworks, sewers, or waste disposal, harbor, improvements of watercourse, public grounds, vehicle parking areas, and for other public purposes, may acquire real property within or to the city by means other than condemnation for industrial sites, may improve and beautify the same, may construct, own, lease, and maintain buildings on such property for instruction, recreation, amusement, and other public purposes, and may sell
Alderman
and
Severnick.
convey such property.
You're laying out a good case, but can we get back to the actual, or
Well,
tie that into
And
the,
that's what I'm saying. Here it says lease. So, I mean, those are the powers of the Common Council, not the Park Board. She has her light on.
oh, Attorney Captain.
The statute, as well as Section 2-4-6, which is Parks and Recreation Board, you might want to take a look at Parents E, Powers and Duties. Number 1,
Is this the state statute?
to govern, manage, control, improve, and care for all public lands located within or partly within and partly without the corporate limits of the city, and secure the quiet, orderly, and suitable use and enjoyment thereof by the people. Also, to adopt rules and regulations to promote these purposes. 2, to acquire in the name of the city for park purposes, and then it goes on. 3, to recommend to the council and the plan commission the buying, leasing, selling, or transferring of lands in the name of the city for park purposes, within or without the city. And so the management, the use, and control is in parents. Excuse me, do I have the floor?
Alderman Severnick, the attorney has
Point of
the
order.
floor.
The paragraph 3 is referring to, and we need to read all of the words when we're interpreting something,
You didn't do it on 2.
to recommend to the council and the plan commission the buying, leasing, selling, or transferring of lands, and this is the crux, in the name of the city for park purposes. And what that is referring to is that the park board just cannot go out and decide that it wants to put a park somewhere, that it wants to lease land because somebody wants to lease it to the city for the purpose, in the name of the city for park purposes. That has to go through that process. But once parkland is acquired, we move into a different section of that ordinance, and that is the management, control, improvement, and care of parks. And when we're talking about management and control, etc., the park board must operate within the budget that has been approved by the Common Council. And so they can't just decide to, put up a new playground or something like that, because that needs to be budgeted for, and then that goes through the whole budget process. But we, in looking at the various sections of the ordinance, which is similar to the statute, you're looking at two different things. I am not quite sure what the purpose of this is, because it makes no difference whatsoever. You do not even need a park board, and whatever the common council wants the park board to do and not do. So if you don't want the park board to manage and control, then you just let us know and then we'll change the ordinance. So that's, excuse me, point of order. I
Yes,
have been
Attorney Cappy,
allowed
I'm
to
recognizing the point of order. Please,
answer.
please answer.
The example that was provided, I believe, and I did write this in a memo to Alderman Kruger, that if the company was something like an insurance company, that has nothing to do with parks and recreation. And so that would be a change of use of park property, and that the park board would not be able to do on its own. The park board would have to come and ask the common council. There's a whole process if you're not going to be using park property for park purposes anymore. The other thing I wanted to mention is I did hear an alderman say that staff should not be doing this on their own and that we need to follow Wisconsin statutes. Staff did not do this. Actually, what happened is that the park board had a question about authority, and they did ask me, and I did provide that opinion. So it was the park board, it was not staff. In addition, the Wisconsin statutes, I know I've said it already, maybe I should, I'm not quite sure how many times I need to say it, but the Wisconsin statutes, it says may have a park board. So you don't even have to have a park board. And whatever powers you want to give them or don't want them to have, that's okay. It's perfectly okay. You guys decide. So whatever you don't want them to do, all you got to do is let me know, and then we'll put that in here.
Again, there's been no reference to eliminating a park board, and I'm just going to read the Wisconsin Supreme Court ruling on this very subject about leases and who has the right to execute a lease on behalf of the city, a park board, and it deals specifically with park boards or the common council. And the reason why this got brought to the court is because there was a park board signature on a lease, and the court said, and I quote, execution by the board and its president together on the lease adds nothing to the lease, nor does it subtract anything from it. The city council was the proper body to authorize the execution of the lease, and the mayor and city clerk, as a result of such authorization, would be the proper parties to sign the same. So is there a way to get this, to make this really short and abide by that ruling? Go ahead.
Can you tell me what the points of law were that were discussed in that case?
I can give you the whole case right here.
Because I know you have mentioned it, but it was not provided to me. It does appear that it is similar to an opinion that I just gave, in that I think you mentioned it was a trucking company. A trucking company would not be something that is for recreational purposes, so that wouldn't be a proper use of park property. So if there was some kind of a lease, that would make sense to me, because it would, like I mentioned, if it was an insurance company or something like that that was going in to ask to use the building, that would be something that the park board, in my opinion, would not have authority to do. They would have to come to the common council. And in the law, we do make a distinguishment between long-term leases, which are longer than a year. Something, and the reason I talk about leases, because a lay person's, I have lay people that call things lease or call things not necessarily by their true legal definition, with all of the terms and conditions. So I'm not quite sure how you define a lease. It may not be the same way that I would define it.
Well, I define the lease based on what was signed.
What I'm asking is, what is it that you want? It's very simple. What is it that you would
Well,
like?
For me, again, it is very simple to have the park department come to the common council with any leases or contracts on the lands that they want to lease or contract out for. specifically what's written here in the Wisconsin Supreme Court ruling. It's simple. If there's a lease to be signed, a contract, because that contract that was signed is between the city of Menasha. It wasn't between the park board and the entity. It was the city of Menasha and that particular entity. The park board is not the city of Menasha. The common council is the city of Menasha. And so it's anything having to do with a lease where it's contracting the city of Menasha to any type of legal obligation to come before the common council, and that includes leases and contracts. I don't know for me to put it any simpler. Does anybody else have any?
When she has her mic on, we can't get in.
There are forms that people do sign when they are looking to use property. This is a use, so, I mean, this is an issue of use of the property. And so all I'm trying to find out is what type of use? Because is there a difference, let me ask this, is there a difference in your mind between a company, or this same company, we'll just say, who is a kayak business going into Jefferson Park and then
I'm not
sitting
going
in...
to allow the merits of who it is and all that. The subject matter is the actual procedure of a lease, not who's leasing it, why they're leasing it, or anything like that. I don't want this whole discussion to get pigeonholed and start attacking or making anybody look bad because it's a particular company. I want to stay on subject on
A
the
kayaking
actual...
company was what I said.
Yes, but the who is doing it or what the purpose is right now, it doesn't matter. It's the process of the actual lease. There's nowhere in the statutes that says that the park board we will only lease to kayak companies and stuff like that. If you can please
No,
turn off your mic.
this is an example. That's why I'm just trying to figure out if it was outside, would that make a difference? If it was out in Jefferson Park, and there was an area in Jefferson Park where a company who is providing bicycles, renting bicycles, how's that? So if a company is providing and wants to rent bicycles, and they're in Jefferson Park, and they want to put up a fence in a certain area and use that certain area, do you want that to come back here?
Of course, yes. And if you could please
Okay,
let one of the other
and
aldermen speak.
that helps immensely.
Okay.
That helps
Okay.
immensely.
Mr. Kirk? Are you okay if I speak?
If it's on subject,
It's
I'll
a-
allow it. Okay.
Sure. I just wanted to comment that you and I had a conversation, I believe it was
Correct.
on Friday, and we talked about a couple things, and I think that we came to an understanding of what you were looking for, and it might
Correct.
help a little bit as well. We were talking about longer-term uses of buildings or spaces. So something would be like a full summer that we would sign a contract of some
Correct.
sort,
Yeah.
would have to come before the council.
Yes.
And/or a specific fee would have to be set by the council for those spaces. And if there was a fee set for a space, then the park department would have the authority to, no, not recommend, but they would have the ability, just like a park shelter, to do that.
Yes, I said that was a possibility to
So
be
those were
considered.
kind of the two things that we talked about a little bit. And
Correct.
we could bring one or both of those back. And the thing being that if we're having someone that wants to use a space for 2 weeks, do you really want that to come to the council versus someone that we're going to sign a contract with for a summer come to the council? And I think that's where the difference is.
Right.
So we could set a rental rate for 12 by 12 square of space or a space in a building or whatever, council approves it. If someone wants to go beyond that for a whole summer, then it would come back as a contract.
Right, and as I said, me personally, that would be okay with me,
Okay.
but there's other members, that may have a differing opinion. I'd like to give them an opportunity to speak. Alderman Sevenick.
That's just the thing, there was no rental rate ever determined. And rental and fee come from the board, recommended to us, because usually like every 1 or 2 years, there's changes brought back to the council, they may add 25 cents to the pool pass or whatever, and it comes to the common council for approval. In this case, there was a lease agreement done for a building that is owned by the city of Menasha that was done without council approval. And when I read everything that I read here, it needs to come back to the common council for final approval. Now, if you want to set it up in the future, as you talked about, that, okay, we're going to set a fee, that if they want to rent that for 6 months, it's this much, or 7 months, I think the community would be shocked if they knew that we're leasing that out for $700 for a whole year. That's why I have issues also. But I want to read the line the city attorney avoided on section 2 here. She was reading, to acquire in the name of the city, item 2, E2, to acquire in the name of the city for park purposes by gift, purchase, device, bequest, or condemnation, either absolutely or in trust, money, real or personal property, or any incorporeal rights or privilege, provide a gift to the city of money or other property, real or personal, either absolute or in trust for park purposes, shall be accepted only after they have been recommended by the board to the common council and approved by said common council by resolution. If you want.
Attorney Captain, you can respond.
I don't
Oh.
have anything to say. That's
okay.
what
All
it
right.
says. I'm not sure, because that has nothing to do with this issue, but it's okay.
I guess it,
And if I can go back?
oh, Alderman Benner.
Thank you, Mr. Chairman. Typically, I would give this over to Alderman Sevenich, but at this point, I think I'd just like to make my comment, and hopefully we can move forward. And my comment is that many times people will have to agree on one thing, and that's to agree to disagree. What you have to do is figure out how we're going to go forward. I don't think that to sit here for who knows how long and debate this back and forth till somehow we figure out how to come up with some verbiage that we can reduce down into writing that would make this document abundantly clear to everybody as to what we need to do, at least for this council. Another council could do something different. This could have been written by another council. It is what it is. But I think that the chairman of the administration committee and possibly another alderman or something, maybe Alderman Sevenich, to sit down with the mayor and the attorney, and not in a matter of debating how we got to where we are, but to figure out how we're going to go forward, create some language we can put in here that's acceptable to everybody, to make it abundantly clear what we should be doing, and just go forward. I really don't care to personally to sit here for another half hour and still have no resolution. I just soon have you folks sit down and iron this out, bring it back to this body so we can debate it with language that we have that I think we find to be acceptable for folks, and then try to go forward from there. And that's my comment. I don't see a lot of positive things happening in the present debate that we're having, and I'd really like to see this just go forward in a positive fashion from this point, and just consider this to be discussion at this time without any action. Thank you.
Alderman Sevenich.
Okay, well, again, I'm just going to read then section 3 then of section 246 of 3. And again, to recommend, this is for the Parks and Recreation Board, to recommend to the Common Council and the Planning Commission, buying, leasing, again, leasing, selling, transferring of lands in the name of the city. I understand how that can't be any more simpler. And then it even went even more specific. It went right into the marina, as well as leasing of building and boat slips within the Menasha Marina, to recommend to the council. So my feeling is that a lease agreement You know, you could have entered that agreement and no one would have known anything. It hadn't been, if you didn't read it in the paper. I read it in the paper. I had been attending all the council meetings. I didn't see it get approved by the common council. That's where I really had issues.
Well, I am in agreement with Alderman Benner that the more productive way to do this is, well, I will get to you, Alderman Collier, would be to assign two aldermen. It doesn't have to be me either. You know, it could be whoever this committee wants to sit down with the attorney and come up with language to bring forth to the council to actually change the ordinance so it is crystal clear. Alderman Collier, do you have anything to add?
All I want to say is, yeah, there was a mistake maybe made. It's not worth killing each other over. We rented it to them for $700. Do I think that's light? Yeah, I do. But like you see, we're trying to get business in the town. The way we could settle this tonight, because we're the council here tonight, and they got an agreement, and I don't think we want to break it because it would look us all look bad. If we could just say, let's let them lease it this year and next year for $700 until
We're
we...
not, Alderman Collier, we're not talking about a particular lease. We're trying to stay on the
Okay.
on the total action. So if you could please stick to the action of the procedures, please.
Then all I want to say is, I hope we can resolve this and not lose anybody from any businesses or anything that might bring people to downtown Menasha. Thank you.
Well,
This has nothing to do with bringing people down.
Alderman Taylor.
What we're talking about here is the powers of this body, that 17,000 people in this community put us here to represent them. And this is a total slap in the face of all 17,000 residents that this administration would allow something like this to happen. We all know clearly that the park board is not in charge of land or leases without this body's permission. The buck stops here. The sad thing about this whole thing, I had to read it in the paper. Is that how we conduct business? That the people that are elected to represent the finances of this city and the property of the city, that we have to read it in the newspaper? I've never seen anything so, I'll leave it at that. But to read it in the paper, I don't care if it's a short term, long term, whatever type of lease you want. A lease is a lease. And this body has to approve those leases, no matter what it is. And we have a very clear document here. There's some aldermen that don't think we have to go by these, our ordinances, and there's some former aldermen that don't think we have to go by these ordinances. And we're not above the law, and that's what the law is. These ordinances, they don't get any clearer. Alderman Severek read it twice already. I could read number 3, section 246, number 3, another 5 times up here. It doesn't get any clearer. There's a mistake made, or there's some liberties be taken by the administration that they got caught. And maybe they need to be censured by this body. But we're not above the law or above this body, anybody up here.
Is that all, Mr. Alderman Taylor? Because I would actually like to move on and just get a approval from the committee, if it's okay for Alderman Severek and myself to sit down with the captain, attorney captain, and work out wording that would be appropriate.
Can we do that without it not being on the agenda? Should we wait?
Attorney captain, could you please, is it okay for us to make that motion or that decision tonight, or is that something that should be placed? Okay, we can do that. So,
I make that motion.
is there a second? Alderman Taylor, second. We'll take a roll call on this one to sit there, and it will be to assign Alderman Severek and myself to sit down with the city attorney to come up with proper wording. Alderman Taylor?
One comment, please. Just one comment on this issue here.
Okay.
Okay, thank you. We ask our business community to abide by our signage ordinance. There's a sign scroll on that building down there, and it's in violation of our ordinance. But this is how this thing just keeps going.
I understand that, but signage is not on.
It's not only the lease, now it's our signing ordinances that are being abused.
Yeah, okay. Okay, we're not discussing that though, so we'll take a roll call on the motion.
Motion carried on roll call 6-2.
Okay, we're going to move on to discussion item number 2, the review discussion of possible action involving City Code Chapter 3, Section 11-3-2, the littering prohibited. This came about because there have been a lot of residents having to do with the news record being tossed on yards, driveways, sidewalks, roofs, top of their dogs, wherever they're being discussed or being placed. I did talk to Officer Paul Zine about this, and he suggested changes on the ordinance, and I was informed by the attorney that changing the ordinance really was not going to do anything, and it wouldn't pass legal muster. So what this is on here for is to find out if there's anything that we can do within city codes to address this issue, or even direct staff to at least talk with the Gannett to try to get this issue solved, which is a common issue throughout the whole city, and quite a few residents have complaints about it. So my first question would be to Captain Attorney, is there anything that you can think of that could be invoked in any of the ordinances to be able to prohibit the practice of just tossing the stuff anywhere on someone's property?
If it becomes litter, we already do have a littering ordinance. So if it starts blowing around and things like that, someone could be given a citation. I believe that in the response that I provided to you, I had recommended contacting the company if there are, and I don't know how many they deliver, but I'm thinking if they were getting 17,000 or how many ever places are complaining about it, if a business would get a lot of calls over and over again, I would think that they would take some action. What I had mentioned was that the changes that I did see that were drafted by Joe, another staff person, were specifically geared towards the newspaper, and it said something about newspaper, and I had indicated that that really is a First Amendment issue, and that it's very difficult to regulate as it relates to specifically newspapers, and that's because what happens is if there's an ordinance that is regulating content, if the courts would consider that to be a content-based ordinance, we go to a strict scrutiny standard that has to be met. And a strict scrutiny standard, I don't know if anyone remembers, but there were ordinances some time ago about handing leaflets out or putting them onto car windows and things like that. And a lot of communities enacted ordinances prohibiting that. And what the courts said were that if we're looking at a strict scrutiny standard, that the cost of littering or somebody having to pick it up and throw it out is not equal to the cost of regulating freedom of speech, because that's what this country is about, is freedom of speech. And so if you're trying to regulate newspapers in some fashion, it's not going to pass constitutional muster.
Alderman Sevenick.
I remember this issue being brought up once before, and specifically relating to the putting on the cars. I think the state created a statute not allowing for that. But I agree with the city attorney. I actually believe I remember this for some reason, hearing this in the media, that this did go to the Supreme Court, and the Supreme Court ruled that this is an issue of free speech and that it's allowed. And I don't know how we could create anything, because it went to the highest court of the land already. I guess to me, the only solution is that the specific companies need to be contacted that are probably, allegedly, I should say, creating these problems, that they should be contacted, and those people who deliver should do a better job of leaving them on the porches and stoops and things like that, and not just out in the terraces, in the streets, and in the driveways.
Is there a recommendation that you would have on who should be contacting the companies?
Oh, I have no recommendation.
Okay.
This isn't my issue. I have too many
As I said,
issues.
this is just to get it out there in the public, because there's
I'm
been a
just
lot of
offering
issues with this. So,
I agree with what the city attorney said, because from my past experience with this particular issue.
Alderman Taylor?
Thank you, Mr. Chairman. I had a daily route of 85 papers, and they constantly beat it in our heads. Kid, hit the porch, or put it between the doors. It's got to be on one or the other. Now the paper started working its way down the sidewalk towards the city sidewalk. Then it hit the city sidewalk now. Now it's hitting the apron of the driveway or the terrace on city property. And I'm sure the Post Crescent does business with us. I think a letter from the city attorney to the Post Crescent would be in order to say, if you're going to do business, at least let's put the paper where it belongs, not on city property, not on the terrace, not in the apron of my driveway. It snows out a little bit. You suck those things up into your snow blower. And I've heard this complaint from many people in the city, and I think there is something we can do about it. I wouldn't even mind inviting the Post Crescent here to a meeting and ask them what they feel they should do about it.
Attorney Kaplan?
It's a problem.
Attorney Kaplan, would that be an appropriate measure for you to be able to contact the Post Crescent via letter to ask them, or suggest, or do anything in that fashion, or would that be inappropriate and not the correct avenue to deal with this?
It depends if you would consider it a matter of, if it's on public property. If it's on private property, that would be different. That would be a private interest, and it would be the people themselves who really should be contacting. Some of people I would expect would not care, and others, perhaps most, would care, so.
On my block, the kid drives in a van, opens the passenger window, and he throws them from the driver's seat onto, it's pretty creative, and but he hits the apron or my terrace, and it's all throughout this district here.
I understand, and the advice is that there's really not too much that can be done with this then.
I don't
Does
really
anybody
believe
has
that.
any
I
other-
think if they're doing business in our community, we should invite them up here, or we should notify them about the problem we're having with this.
I don't think inviting them to a committee or council meeting is an appropriate action for
Well,
something like this.
at least a formal letter out to them. They're littering on city property, like it or not. We don't let people put signs on, except for election signs out, and they can't be on the terrace.
I will work with the city attorney a little bit more to
Thank
see
you.
if there's something that can be done on this then. And but as a committee and council, there's nothing that we can do at the present moment. So we will move on to item E, adjournment. Is there a motion to adjourn? Oh. Hold on.
I just ordered the Post Crescent the other day. I said, hey, put a box on my mailbox, a little carrier thing. They put it in there. So have people do that.
Yeah. Can we have a motion to adjourn?
For shorties.
Motion to adjourn.
We have a motion. Do we have a second? We have a second. All in favor? Aye. We are adjourned.